I was thinking the other day about what happens during the course of a negotiated settlement. The defense will oftentimes come back and make a lowball settlement offer. And I was trying to think back about when, if ever, an attorney, a plaintiff's attorney, a lawyer who represents an injured patient, an injured victim, has ever gone ahead and accepted the defense's initial lowball settlement offer. I can't think of a single time when that would occur. I can't think of a single instance when that would occur. You know why? Because you know, in fact, in practically every situation, when the defense makes their initial offer, they're doing it for a number of key reasons. They want to alert your attorney to the fact that yes, they have come to the table and now they've made a settlement offer. Now, for the very first time after years of litigating your case, they now have actually offered money to settle your case. You think that they have now come to the realization that they are liable and responsible for your particular injuries. Well, let me disavow that perception. The reality is, when they start to negotiate, it does not necessarily mean that they are accepting responsibility for the doctor's actions or for the careless person's actions or for a careless company's actions. Instead, what they are doing is making a calculated business decision that it is better financially to go ahead and try and resolve this for a certain amount of money now, rather than run the risk of getting a jury verdict which far exceeds any amount of money that they could offer at this point, and additional costs, additional defense costs, and everything that goes along with that. So when somebody starts to negotiate, don't think for a second that just because they start negotiating, it means that they are fully accepting responsibility. For the purposes of settlement discussions, it means that liability, who is responsible, is no longer a factor. There is still the possibility that you, as the injured victim, as the injured patient, may be partially responsible for your injuries. And if that's the case, now the defense will use that as leverage to try and reduce any amount of money that they are offering, claiming and arguing that if your case goes to trial, in all likelihood, you, the injured victim, the injured patient, will be found to be partially responsible. So that goes into the mix. But once you start talking about money, it's no longer whether or not we accept responsibility for what happened. Rather, it's okay, let's figure out what this case is worth from a damages standpoint. So now here's something else that's fascinating that nobody talks about. Each side is looking at your damages with the same exact eye. We know your age. We know how you've been disabled. Each side knows the extent of your medical injury. Each side has copies of your medical records. There is no hiding anything here. Each side knows how your injuries have affected you and your life and your family life. So there are no secrets when it comes to damages. So you might be thinking, how is it possible then that two sides, the plaintiff and the defense, can look at the same set of damages, the same set of facts concerning your injuries, and come to two totally different conclusions? That's the remarkable thing about these types of cases, and importantly, about negotiation. So when the defense makes an offer, they have come to the conclusion that yes, your injuries have a value. Let's see if you, the injured patient, and your attorney are willing to take the first lowball settlement offer that we make. Because if you do, guess what? Now we've scored a home run and they've saved a tremendous amount of money. Has anyone ever taken the defense's lowball settlement offer as their very first offer? Honestly, I've been doing this now almost 34 years. I can't think of a single instance where an attorney who represents an injured patient has actually gone ahead and accepted the defense's first lowball settlement offer. It just doesn't happen. And it would not, in my opinion, be in the best interests of you, the injured patient, to go ahead and do that. Why? Because that's just it. It's just their initial offer. We know that in all likelihood they have more money to offer. Unless, there's a but. But if they turn around and say, listen, this is the only offer we are going to make. We don't have a single dime more. Don't ask us for another dime. This is all we have. So it's either take it or leave it. In that instance, now we have a decision to make. Now we have a discussion and we talk about the risks, the benefits, and the alternatives of accepting or rejecting this particular offer. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and these wrongful death cases in New York. You know, I recognize you're watching this because you want to see the beautiful scenery. No, that's not why you're watching it. You're watching it because you likely have questions about your own matter. Well, if you have not yet started a lawsuit, but are thinking of doing so, and your matter happened in New York and you still have questions, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.